I served a little under 28 years in IDOC. I was 17 at the time that the crime happened.
25 years, 3 months, 3 weeks, and 3 days.
I was 17 when I was charged with my offense, and I was 20 when I was convicted.
I was 15 years old when my crime happened.
I was 15 years old when I committed my crime that resulted in my sentence of life without parole. I was incarcerated for 27 and a half years total.
The history of the Illinois legal system as it relates to young people is one of both profound hope and also real disappointment.
Illinois is the state that had the world's first juvenile court a century and a half ago.
Kids were not going to be treated just like adults. They were going to be given additional protections based on the fact that we recognized that kids were different, and there were different ways that we could intercede at an early age and provide a different level of services to help reform and help sort of, do what we would want to do in terms of remember that they are children and we should treat them as such.
In the 90s, gangs were kind of prevalent, and Eric got involved.
I grew up in a neighborhood, in a family actually too, that was involved in drug dealing.
It's some ugly things that happen. Being entrenched in that lifestyle, people sometimes lose their life. I can't say that I was the person that took someone's life, but I knew that someone's life was going to be taken, and I was tried and convicted for it.
It was me thinking that I was ready to live that adult life, and just finally realizing that I didn't know everything that I thought I knew.
The law for felony murder and accountability has profound implications when it relates to children and our criminal legal system. Felony murder is the concept that if a death occurs during the course of the commission of some other kind of felony, you are going to be charged not just with the other felony that you may or may not have done, but also with the death that occurred. And it will be treated as if you intended to kill that person. Accountability is based on the idea that if you and I agree to do something, and even if you're the one that did it, because we agreed, I'm going to be every bit as guilty for the thing that you did. As our court systems were moving to narrow just who got to be in juvenile court, and were moving more and more children into the adult legal system, this was in the 1980s and early 90s is when you started to hear the phrase, old enough to do the crime, old enough to do the time.
Basically what it was at the time, the judges had no discretion. It was either natural life without the possibility of parole, not guilty. That was the only sentence that the judge could give me because it was 2 homicides.
Life without possibility of parole, what a mouthful, It's a ridiculous legalism that doesn't have the punch of the death penalty.
Should we abolish life without parole for all kids? Or is the problem giving life without parole to really young kids? Or is the problem giving life without parole in a mandatory nature that's sort of one size fits all? If you do X, you receive Y. That was the question. Those 3 questions were in front of the court.
Miller v. Alabama is a U.S. Supreme Court decision. It said that sentencing anyone under the age of 18 of a mandatory life sentence, meaning the judge had no choice if they were found guilty but to sentence them to life without the possibility of parole. The U.S. Supreme Court said that that was considered cruel and unusual punishment, and they would have to take into consideration the person's age and factors that they have found out since.
What Miller did was ban the sentence of life without the possibility of parole for people whose sentences were the result of offenses or incidents that occurred when they were under the age of 18. But it banned only mandatory sentences, and that might have seemed like a very narrow thing, but what Miller did is it went a little further than a child for whose actions, whose crime is not the result of their transient immaturity.
So I was watching Rachel Maddow on MSNBC, and she broke it down in the simplest terms. And I was like, oh my God, I got a chance.
It felt like just a relief. You know, even though I know it wasn't gonna happen 2, 3, 4, I didn't know exactly when, but it just turned from knowing that I wasn't going home to knowing that I would eventually, you know, get out.
The impact of Miller statewide was unbelievable. You know, federal-wise, it was unbelievable both ways, because it was basically saying that people that had mandatory natural life that had been given no hope was going to get a chance at review, was going to get resentenced possibly, and that was unheard of. So it was a lot of skeptics, it was a lot of, that's not going to happen, how this going to happen, you know, the world's coming to an end, things like that. But, you know, so yeah, it was definitely like, wow, you know, I can't believe this is happening.
I don't remember the exact moment that I heard it, but I remember generally when it came out that I was really excited, because I had been watching the previous decision that came before Miller, which is Roper and Sullivan. And so I can kind of see the progression of the cases happening. And so when Miller came out, I was really ecstatic, because it obviously had an impact on my case, but also some of the other people that I knew that were incarcerated as well.
We have the Miller decision, which created the opportunity for some individuals to go back into court and challenge their previously imposed life sentence. We need to do more, because some of those individuals who went back to challenge their life sentence received another life sentence. Some individuals who went into court asking for their sentence to be reviewed were told, no, you don't get to have your sentence reviewed. Some of those individuals who were 18, 19, 20 years old, who received a mandatory life sentence, some of whom received that mandatory life sentence for something that someone else did and didn't foresee, didn't understand, couldn't really comprehend just what any of this meant. And they have been told no. And so more work has to be done in order to make sure that everyone is being given at least a shot, at least an opportunity to be heard, at least an opportunity for a judge or someone in a position of power to make a determination about whether or not was your youth adequately considered. There were over 100 individuals serving a life without parole sentence in Illinois at the time of Miller. And in the years since then, a number of those kids didn't go home because they were resentenced to a different sentence. They went home because they were innocent. And Miller gave us one opportunity to get back into court for some individuals, but has not given the opportunity for everyone else. And so the work can't just be in the courts, the work has to be in our legislative bodies, and the work has to be out in the community.
Restore Justice bringing youthful parole to Illinois has been one of the most significant changes in the criminal legal system in the past few decades. We're focused specifically on young people who are sentenced to extreme sentences for decades. We are focused on making sure they have an opportunity to come home, especially when they've demonstrated that rehabilitation.
Yes, it was very exciting for us to be able to pass HB 1064. Creating an opportunity for parole for people under 20 who would prospectively would be sentenced to life, some form of life without parole. I think the greatest excitement of the passage of that bill was the bipartisan support which we were able to gain in the Illinois Senate.
Being an impacted person is one of my bigger contributions to people that I left behind, you know, to just be an example of what long-term incarceration can look like.
I don't feel like I've been gone 28 years. I don't feel like I've been removed from society for almost 30 years. So it's easy for me to have a conversation with somebody that's 16, 17, or 18 years old, because I know that they think the same way that I did when I was that age, you know, and it's funny just to see the reactions when I tell them about my story, and I tell them that I just came home and I just did 28 years, and that, you know, I was locked up for murder, and, you know, so those are the things that kind of like grab their attention.
My story is powerful, our story is powerful, and I don't think no one else could do it but us, because when you talk to a legislator, it's easy for somebody else to be like, well, you know, these guys are really good guys, or these guys need a second chance. But it's different when that guy's in front of you and you can feel his presence, you know, and he can tell you who he is, you can see who he is, you can feel it. You can, you know, it's different when I'm in your face and you see what I do for a living, and you see the skies are falling, and I'm paying taxes, and I'm not getting in trouble, and I'm probably a better citizen than most. So I think that it gives legislators a different perspective. Not all, but it changes some minds, and that's all we want. We just want to change minds, or the chance to change minds.
Children don't fall out of the sky evil, in my experience. They come to a situation, the product of many things that have happened around them and within them. And how can we as a society invest in that human being and make it so that they don't end up in our court systems? I think that is really what the goal of a system should be.